Chitra Devi, Assistant Professor, Department of Commerce, Professional Accounting from VV Vanya Perumal College for Women. So in this video, we are going to see a very important topic in business law, that is Indian Contract Act 1872. So it is one of the very important act in business law. So we'll see what are the requirements, or that is what are the essentials of the Indian Contract Act and various types of contract in the act. So let us see first what is a contract. So contract is nothing but an agreement between two or more parties enforceable by law. So if it is a contract, there should be two terms, it is compulsory. So what are the two terms? Agreement and enforceable by law. So if the two concepts, that is if the two concepts are exist, we can say it is a contract. So contract is agreement with enforceable by law. So first we will see what is an agreement. So agreement is a promise or set of promises that is forming a consideration. If a promise or set of promises performing for consideration, that is called agreement. So when we are going for an agreement, we will see two concepts, that is offer and acceptance. If both the words are exist, we can say it is an agreement. So what do you mean by offer and what do you mean by acceptance? So offer means if the seller is ready to sell the product. So that if he offers the product, I am ready to sell the goods, I am ready to give my product to the another person. So that is called offer. And it is also called proposal. The another term for offer is also proposal. Then acceptance, if the buyer is ready to accept, that is ready to buy the goods offered by the seller, is called the acceptance. If both the terms are exist, we can say it is an agreement. So we can say contract is an agreement enforceable by law. So what do you mean by, we can already see what is an agreement. So agreement is both offer and the proposal, or offer and the acceptance. Then we will see what is enforceable by law. So what are the essential requirements they have mentioned in the Indian Contract Act as per the law in the year 1872. If it fulfills all the essential requirements, we can say it is enforceable by law. So what is contract? Indian Contract Act 1872. What are the requirements to fulfill? We can say it is an Indian Contract Act. Okay. So these are the very essential elements of a valid contract. So the first one is, it should be an offer and acceptance have to be made. The seller is ready to offer, that is ready to sell the goods, and the offer, that is the buyer is ready to accept the goods. So that should be, both concepts should be exist, offer and the acceptance. And the second essential element is, there should be a lawful consideration. So what are the essential requirements in the act? It fulfills all the essential requirements, that is lawful consideration. Then there should be a mutual consent between both the parties, both the buyer and the seller, with a mutual consent. Buyer also ready to accept the goods with their own interest, and the seller also ready to sell the goods with his own interest. Nobody should compel them to buy or sell the goods or services. So both of them are ready to sell and buy the goods by their own interest. So that is called, that should be a free consent. Then the object of the agreement should be lawful. Already we have seen, as per the legal providence, they have to continue their process. Then the contract must be enforceable by law. So if it is fulfill all the conditions, we can say it is a valid contract. Next, types of contract. It is based on the various elements. So first one is based on enforceability. So what do you mean by based on enforceability? Valid contract. In this we have divided, that is we have classified the contract into 6 types. So first one is valid contract. So we can say we have already seen a contract. So the contract should complete, that is the fulfill both an agreement and enforceable by law. If both, it fulfills both the concept, that is agreement and the enforceable by law, we can say it is a valid contract. So an agreement enforceable by law, it is considered to be a valid contract. So it satisfies all the requirements. We have already seen the elements. So it has to fulfill all these elements. Offer and acceptance should be made. It should be a lawful consideration. It should be a free consent. And it should be an agreement, and it should be an enforceable by law. If these all the elements are exist in the contract, we can say it is a valid contract. Okay. So second one is void agreement. An agreement not enforceable by law. It should not satisfy any one of the elements or requirements in the act. We can say it is a void agreement. Then voidable contract. What do you mean by voidable contract? An agreement which is enforceable at the option of one or more parties. That is, somebody insists them to enter into the contract, means then we can say it is a voidable contract. Next one is void contract. So what do you mean by void contract? At the very beginning it was a valid contract. It was an agreement. It was also enforced by law. So at the time, at the end of the time or at the end of the middle of the time, it was not enforceable by law. So we can say it is a void contract. We can see an example. For example, a book company have given the author to write the book. So they have given the offer and the author also accepted the offer to complete the book. So there will be an agreement and it will be enforceable by law. Both are exist in the beginning of the time. So at the end of the time, so during some disease, the author was dead, so he cannot complete the book. So that was not enforceable by law. So that we can say it is a void contract. The agreement was okay, but it is not, because the author not fulfill the condition. He cannot give the book. So we can say it is a void contract. Next one is unenforceable contracts due to some technical effects. So some evidence may not be submitted properly. So we can say it is an unenforceable contract. These are the contracts which cannot enforced in a court of law. So as per the law, we have to provide the evidence for that. So in technical defects, if they may not submit the evidence, we can say it is an unenforceable contract. Next one is illegal contract. So all the contracts should be legal contract. If any illegal product should be sold or illegal products should be in the process, means we can say it is an illegal process or illegal contract. So these are the contracts based on the enforceability. Next one, based on the method of formation, how it is formed. On the basis of formation, we are dividing the contract into two. First one is formal contract and the other one is simple contract. Let us see first what do you mean by formal contract. So formal contract means it is fulfill all the essential. As per the valid contract, it is an agreement. It is also enforced by law. It satisfies both. It should be signed, it should be sealed, everything. It is mentioned in the court. So everything it is in formal contract. So in the formal contract, that is, there are two types. First one is contract under seal. So both the parties are signed and it should be verified. It should be sealed, means we can say it is a formal contract. And the other one is contract of records. We can say, for the example, court judgment. So that is all records. So we can say that is also a formal contract. So what do you mean by simple contract? Other than the formal contract. So if it is not sealed, if it is not a court judgment, we can say that is a simple contract. Another name for simple contract is parole contract. So these are the two methods based on the formation. Yes. Next will based on the extent of performance. So based on the performance, we are dividing the contract into two types. One is executed contract and another one is executory contract. So the first one is executed contract. So the contract is fully completed. Both the buyer and the seller signed the agreement and it was completed completely. So the buyer also bought the goods from the seller and the seller also received the amount from the buyer for selling the goods. So if both the agreements are fulfilled and completed, we can say it is an executed contract. Then what do you mean by executory contract? If only one obligation is completed and the other obligation is not completed, means we can say it is an executory contract. For example, the seller sold the car to the buyer, but buyer did not pay the amount for the car to the seller. So only one part of obligation was satisfied and the other obligation was pending. He did not receive the money for that car. So until it was satisfied, it is known as executory contract. So next one, based on the obligation, we are dividing the contract. Unilateral, bilateral and multilateral. So unilateral contract. Unilateral means only one side. There is an obligation on the part of only one party when the contract is concluded. For example, we can say court judgment. For example, if a person met an accident, so who did the accident? The person has to pay the money. It was given by the judgment, court judgment. So only here is the only obligation. By the person who did the accident, he has to pay the money to the person who met the accident, the person who injured. So in here only the one party has that obligation to pay the amount. Another party, he need not to pay the amount. So this we can say, and we can say a divorce case, only the husband has to settle the amount to the wife. The wife need not to settle, she doesn't have any obligation to settle the amount. So court judgment is a very good example for the unilateral contract. And the bilateral contract, bilateral means both the parties. I also give the product and the seller also sell the product and the buyer also give the amount for the product. So both have the obligation, means we can say it is a bilateral contract. Multilateral contract means more than two parties are involved. We can say it is a multilateral contract. If maybe if the building A and B has the property, house property, so they both are willing to sell the property, means so two parties are involved and buyer also. So if more than two parties are involved, because there are two sellers and one buyer, here there are three parties are involved. So in this case we can say it is a multilateral contract. So these are the, and based on the obligation. The next one is based on the mode of creation, express contract. So either it may be expressed in words, that is spoken words, or written words. So it is mentioned in either in written words or spoken words. It should be expressed either in terms. It may be in spoken or it may be in written words. So if it is expressed, we can say it is an express contract, expressed in any one of the term. Implied or inferred contract. If it is not expressed in spoken or written, it should be a followed procedure. It should be a practice. That is called implied or inferred contract. So, for example, there is a no spoken words or there should be a no written agreement. So, buyer as usual pay the amount for the goods. The seller, what is that? For example, the seller regularly send the goods on Friday and the buyer regularly send the amount on Saturday. So, it was a regular process, regular procedure they will follow. There will be no written agreement or there will be no spoken words. So, it is followed in the practice or procedure. We can say it is an implied or inferred contract. So, the last one is e-contract. So, e-contract means electronic contract. If you are selling the online purchase, if you are buying the product through online purchase, we can say it is an e-contract. We are sending the email, we are purchasing the product from the Amazon and Flipkart. So, these are the contract through the electronic devices. Some electronic devices we are giving the agreement and enforceable by law. This is called e-contract. So, these are the various contracts in Indian Contract Act 1872. Thank you.